Welcome to this presentation, No Federal Heat Rule. Here's how OSHA finds employers. As stated on the official website of the U.S. Department of Labor, DOL.gov, OSHA proposed a heat illness prevention standard back in 2021, but as of June 2026, no final federal heat-specific regulation has been promulgated. Instead, OSHA uses the General Duty Clause of the Occupational Safety and Health Act of 1970 to fine employers who fail to protect workers from heat. Between 2011 and 2022, the Bureau of Labor Statistics recorded 479 heat-related worker fatalities. With rising summer temperatures and no federal rule in sight, understanding how OSHA enforces heat safety is more important than ever for every employer. No federal heat rule. What it means. The U.S. Department of Labor published an advance notice of proposed rulemaking for heat illness prevention in October 2021. But as of June 2026, no final standard exists. The proposed rule would have required employers to provide water, rest breaks, and shade at specific temperature thresholds. But the rulemaking process has stalled through multiple administrations. The Small Business Regulatory Enforcement Fairness Act review was completed in 2023, but no proposed rule emerged in 2024 or 2025. The 2026 regulatory agenda is still listed in the proposed rule stage. This regulatory gap means employers cannot simply check a box for heat compliance. They must proactively address heat hazards using the General Duty Clause. General Duty Clause. Section 5A 1. Section 5A.1 of the Occupational Safety and Health Act of 1970 requires each employer to furnish each employee employment free from recognized hazards that are causing or are likely to cause death or serious physical harm. For OSHA to cite under the General Duty Clause, it must prove three elements. First, a recognized hazard exists. Second, the hazard is causing or likely to cause death or serious harm. And third, feasible abatement methods are available to the employer. Heat is a recognized hazard. The National Institute for Occupational Safety and Health, the American Conference of Governmental Industrial Hygienists, and industry practices all acknowledge heat stress risks. Feasible abatement includes water, rest, shade, acclimatization, training, and engineering controls like cooling fans and ventilation. Courts have repeatedly upheld General Duty Clause citations for heat where employers failed to take feasible steps. OSHA penalty structure for 2026. As stated on the official OSHA website at osha.gov/penalties. The maximum penalty for a serious violation is $16,131, and for a willful or repeat violation, it rises to $161,323 per occurrence. These amounts are adjusted annually for inflation. A single heat-related citation under the General Duty Clause is typically classified as serious, carrying a maximum of $16,131, but multiple citations per worksite can quickly add up to six figures in total fines. If OSHA determines the employer knew about the heat hazard and did nothing, the violation can be classified as willful, up to $161,323 per violation. Failure to abate a cited heat hazard costs $16,131 per day until corrected. Proactive compliance is significantly cheaper than defending a citation. Heat National Emphasis Program. As stated on the official OSHA website, the Heat Illness Prevention National Emphasis Program was launched in April 2022 and expanded in 2024 to include indoor heat hazards in warehouses and manufacturing facilities. The NEP targets high-risk industries including agriculture, construction, warehousing, manufacturing, landscaping, delivery services, and oil and gas extraction. Inspections are triggered when the heat index reaches 80 degrees Fahrenheit or higher, as well as by worker complaints and prior violations. Since its launch, OSHA has conducted over 1,200 heat-related inspections under the NEP, issuing citations primarily under the General Duty Clause. Common citations include failure to provide water, rest, shade, and acclimatization programs. State plans. 22 states have their own OSHA. As stated on the official OSHA website at osha.gov/state-plans, 22 states and territories operate their own OSHA-approved workplace safety plans. These states can adopt their own heat standards while the federal rule remains stalled. California has the most comprehensive heat standard, known as Cal OSHA Title 8, Section 3395. It requires fresh drinking water, access to shade, rest breaks, a written heat illness prevention plan, and acclimatization protocols for both outdoor and indoor workers. Washington, Oregon, and Minnesota also have state-specific heat standards. The remaining 28 states are under direct federal OSHA jurisdiction, where only the General Duty Clause applies for heat enforcement. California's heat standard. The model. As stated on the official California Department of Industrial Relations website at dir.ca.gov. The Cal OSHA Heat Illness Prevention Standard requires employers to provide fresh drinking water, access to shade, rest breaks, and a written heat illness prevention plan. California's standard covers both outdoor and indoor workplaces. Water must be fresh, suitably cool, and provided at no cost to employees. Shade must be present when temperature exceeds 80 degrees Fahrenheit. Employers must allow and encourage cool-down rest breaks. High heat procedures kick in above 95 degrees Fahrenheit, requiring additional measures. Cal OSHA also requires employee training and acclimatization protocols. Violations can result in fines up to $25,000 per serious citation. Compliance strategies without a heat rule. As stated on the official OSHA website, even without a specific heat standard, employers should follow recognized industry practices. The 3 pillars of heat safety as recommended by OSHA, NIOSH, and ACGIH are water, rest, and shade. Provide unlimited cool drinking water, scheduled rest breaks in cool areas, and access to shade. Acclimatization is critical. Gradually increase worker exposure to heat over 7 to 14 days. Most heat-related fatalities occur within the first few days on the job. Develop a written heat illness prevention plan and train supervisors to recognize symptoms of heat illness. OSHA's on-site consultation program offers free and confidential advice to small and medium businesses. No citations or penalties result from these consultations. Record keeping and reporting requirements. Under 29 CFR Part 1904, employers must record work-related injuries and illnesses on OSHA Form 300. This includes heat stroke, heat exhaustion, heat cramps, and any heat-related condition involving medical treatment beyond first aid or days away from work. Fatalities must be reported to OSHA within 8 hours. Inpatient hospitalizations must be reported within 24 hours. This includes heat stroke deaths and hospitalizations for serious heat illness. Failure to record or report can result in separate citations. Willful failure to maintain accurate records can result in penalties up to $161,323. Proper record keeping is a legal obligation, not just a best practice. What employers must do in 2026. Even without a federal heat standard, OSHA expects every employer with workers exposed to heat to take proactive steps. Here are 10 action items every employer should implement in 2026. 1. Provide unlimited cool drinking water, mandatory rest breaks, and access to shade. 2. Implement acclimatization protocols for new and returning workers over 7 to 14 days. 3. Train employees and supervisors to recognize signs of heat illness. 4. Develop a written heat illness prevention plan. 5. Monitor the heat index at the worksite. 6. Establish emergency response procedures for heat stroke. 7. Record all heat-related injuries on OSHA Form 300. 8. Report fatalities within 8 hours and hospitalizations within 24 hours. 9. Conduct periodic workplace heat hazard assessments. 10. Check state-specific requirements if operating in a state-planned state. Legal landscape and future outlook. As stated on the official Federal Register website, OSHA's heat rulemaking is listed in the proposed rule stage for 2026. No final standard is expected this year. The heat NEP continues through 2026 with inspections targeting high heat industries. General Duty Clause citations remain OSHA's primary enforcement tool for heat. No specific standard is expected before 2027 at the earliest. A new presidential administration in 2025 has shifted OSHA's regulatory priorities. The heat standard may face additional delays, revisions, or potential withdrawal. Whistleblower protections under Section 11(c) of the OSH Act protect workers who report heat hazards. Retaliation against workers who complain about heat safety is illegal and can result in back pay remedies. Summary. Key takeaways. Let's review the 7 most important things to remember. 1. No federal heat-specific standard exists as of June 2026. OSHA enforces via the General Duty Clause Section 5(1) of the OSH Act. 2. Maximum penalties are $16,131 for a serious violation and $161,323 for a willful or repeat violation. Failure to abate costs $16,131 per day. 3. The HEAT National Emphasis Program, launched in 2022 and expanded in 2024, actively targets agriculture, construction, warehousing, and manufacturing. 4 to 22 states have OSHA-approved plans. California, Washington, and Oregon have their own enforceable heat standards. 5. Action items include water, rest, shade, acclimatization, a written heat illness prevention plan, training, heat monitoring, and proper record keeping. 6. Free confidential on-site consultation is available at osha.gov/compliance assistance. No penalties result from participation. 7. Full details are available at osha.gov/heat-exposure. Scan the QR code on this slide for the official OSHA Heat Safety Portal. This presentation is for educational purposes only. Consult your legal counsel for specific compliance advice.